Then the great demonstrations began in 1960, and we represented the movement. We represented Dr. King, we represented CORE, and in its early days we began representing SNCC. And then dozens of ad hoc community groups, the Albany movement, the Jackson movement, and the Nashville movement, and so forth. And we brought the lawsuit that permitted Martin King to march in Selma. And we represented Dr. King in Birmingham. Indeed, the movement brought about 40 cases to the Supreme Court of the United States. And we represented them in virtually all of those cases, and we won them all except one. Well, the Legal Defense Fund was founded in 1939, and it had a small staff then of just 2 or 3 lawyers, and it was headed by Thurgood Marshall. And then our job was solely to make precedent. We weren't big enough to do very much along the line of enforcement, and we started in with the cases to integrate the universities. And when I came to work here in 1949, we had before the Supreme Court of the United States the cases which were aimed at integrating the University of Texas and the University of Oklahoma. Then followed the school segregation cases, Brown against Board of Education, and that, of course, was the great landmark case, one of the great cases, you might even say perhaps the greatest case, decided by the Supreme Court of the United States.
Well, the Legal Defense Fund had initiated a suit here to desegregate the public schools in Orleans Parish. Mr. Bush was one of those who joined in with a number of parents to protest to the school board the inadequacy of the school facilities. We came to the conclusion that just asking for additional school facilities was not an answer to the problem that Negro children in New Orleans were facing, so we filed this suit to desegregate the schools in the system.
It's been 14 years since the suit was filed and the case was decided. And up until now, there's very little integration in the Orleans Parish school system. It is a little better, I'll admit that.
Mr. Bush, we started this case in 1952. In 1960, the first 4 Negro children desegregated the public school system of New Orleans. At that time, did any of your children go into the public school desegregation program?
Not one, not one.
Have any of them gone into desegregated schools since 1960?
No, not one.
In other words, all of your children have attended Negro schools.
That's right.
Also, there was a case against the city of New Orleans to require them to employ Negro policemen. Is that right?
Yes, we did that around 1947.
While a student at Dillard University, I took the police examination along with several other friends. I passed in the high 90s, and all of the men who took the examination at the time I took it made reasonably good scores. However, we were passed over for appointments, actual appointments. On the occasion of the second passover, I alerted your office, and when my name was passed over for the 3rd time, I requested assistance from the Legal Defense Fund. This brought your office into the case, and we were successful, of course, in eventually being appointed. June 16th, 1950, 2 of us were appointed to become the first Negroes on the police force.
You did serve on the police force?
I did.
In active duty?
For a period of 5 years.
I think the PQ case in general opened up jobs for more Negroes. Since that case, they've had this number of policemen hired. At present, they have about 5 Negro women working in communication. They have 1 Negro woman in the central lockup, and there are quite a few Negro sheriffs. Before there were none.
The case became moot because we were actually assigned, the case was to come up on the 20th, and we were appointed on the 16th.
Yes.
The pressure generated by the case really made the actual arguing of the case in court unnecessary.
The main problem was that I used to ride number 6 bus, and you get on number 6, You pay your money, and if one white person sit on the seat, you make your women and children, all Negroes sit in the back. You get out and transform, cap the street. You give your money in the front door and you run in the back door. Now that was the reason that I brought the suit on this thing. I just couldn't stand to give my money through the front door and pay as much as the white, and then run in the back door. Yeah. And that's when I contacted you, because you contacted Legal Defense Fund. Yeah. And we got the suit started.
You and others have indicated to me many times that you felt that maybe the best route for you would be through the courts rather than maybe in the streets or something like that. You never did actually participate so far as any violence or anything like that to accomplish your objective. And I assume that's the reason why you contacted Legal Defense for going at it in the proper way.
Yeah, that's true in the case, because you cannot win with bricks and bottles. You got to go through the court procedure.
After the Brown decision, our work began to change somewhat. We still continued with precedent-making cases. We brought the case that required integration of hospitals. And we brought a good number of cases under the 1964 Civil Rights Act, which upheld its constitutionality. But we had many cases that were principally involved with enforcement. We brought the Meredith case. We integrated the University of Alabama. In fact, there is not a southern state university system which was not sued by us to require its integration, with the exception of Arkansas. And they integrated when a lawsuit was announced, and we didn't actually have to go through it.
Things are getting worse rather than better for the majority of poor Negroes in this state. And one wants to ask, I assume, what is the Legal Defense Fund doing in response to this? At most, I can say that our gestures are minimal, even though we're trying as hard as we can. Our resources are limited, and there's great need for at least 15 or 20 legal defense funds. We're spending a huge amount of our time, I think, on the community aspect of law, because I think over the years we've learned that lawyers arguing cases in court really bring about very little change unless you can begin to deal with the problems of law and its applicability to communities and how people live. We aren't going to make very much progress. As a result, we're dealing a great deal in school desegregation because we're still faced with a Negro population with less than 7 years medium education. We're beginning to start a new welfare litigation program because welfare, we find, is the central issue in the state because it means for many, many Negro citizens the difference between eating and not eating at all. While the welfare payments in the state are woefully inadequate, even the 26% of need that the state determines that it's necessary for a family to live decently, we find that even with this inadequate provision of the welfare program of the state of Mississippi, that many of the people who are still entitled to this are not getting it because of racial discrimination or because of maladministration by welfare officials. There are many practices of the Welfare Department which are in clear violation of state and federal law, and I think we've begun last week by filing our first suit against the Welfare Department to require, under the Due Process Clause, a prior hearing before termination of welfare benefits, the first of an attack on unconstitutional, in our estimation, and illegal welfare practices.
We have purchased from the Jefferson County Board of Registrars the complete list of registered voters in the Bessemer Division of Jefferson County, Alabama, consisting of approximately 50,000 names. The persons sitting in front of me are using the voter list to check whatever names may be found on the jury roll. To the left of me is a blackboard where we tally each and every name. The voters list contains racial designations by number, and we are able to determine which persons are Negroes and which persons are not. We hope to prove what we think we already know, that the board who is charged with going into every beat and precinct in the area and filling the box with qualified jurors, we hope to prove that they have not done this, and that there are a great number of whites as opposed to a small number of Negroes. Hence, the box is unconstitutionally constituted.
Henry Marsh is one of our cooperating lawyers, and he has brought a large number of cases for us, including a case against the Philip Morris Corporation, which, before our lawsuit, was guilty of discrimination in employment. Nothing can be more important than the abolition of discrimination in employment. It determines whether a family will grow up together, whether it will grow up in health, whether a child can get an education and a higher education. We are giving all the energy we can to putting an end to racial segregation and discrimination in employment.
Ms. Oldner, how long have you been with the company?
29 years.
And what's your job? What do you do?
Take moisture.
You test the moisture in the tobacco?
Yes.
How much are you paid an hour?
$2.21.
$2.21 an hour. Is there anyone who works with you?
This white man next to me.
And does he do the same thing you do?
Same job.
And how much does he make an hour?
$2.55.
$2.55?
Yes.
And you both do the same thing?
Same thing.
And you think you're entitled to be paid the same thing he's paid?
Yes.
Well, we'll find out when the case is decided whether the court agrees with you or not, but I think so too.
I hope so.
Now, are there other examples in the company of Negroes who do the same work as white employees or work equally as hard and yet they receive less pay?
Well, quite a bit of that going on my floor now, Mr. Marsh. That's one reason I guess I institute the suit against the company, because we have Negroes on these jobs doing similar jobs to the white man, but getting less pay for them.
Mm-hmm. Well, I noticed you sued the union. You remember we sued the union. Why is it that you sued the union? You feel the union also?
Well, I mean, I have went to talk to the union officials several times about these jobs and elevating these jobs, so forth, but they didn't never give me no satisfaction on they gonna do anything about the job. So otherwise, the only thing the union was doing was eating the company and holding the Negro employees down and keep them getting better paid jobs.
Assuming that Philip Morris came, let's say, almost up to par, 80% of what we are asking for. So what happens then?
As you know, since the suit has been filed, the company has made a vast improvement. And by the time we get to trial, they will be able to show a much better picture than they did at the time the suit was filed. This gets us into the question of whether the case is moot or not. We think, however, that the company has so far to go that they will not be able to moot the case by the time the case is tried. We need a precedent very badly in this area, not just for the problem at Philip Morris, but for many other companies all over the country, where the evidence won't be as clear as we think it is in this case. So we're going to press on for the precedent, hopefully to not only help you and the 400 Negro employees at your company, but also to help the thousands of Negro employees all over the country in other companies who have been discriminated against because of their race. One of the officials of the company testified in the depositions that the Negro employees were happy and satisfied with the promotion opportunities, that they had no objection. Now, is that true?
Too many times for things I have especially been in for the girls that's been really mistreated on these jobs, and they don't give you any satisfaction whatsoever. They tell you they're going to do something this day, and the next day they make another rule. Every day it's a new rule in Philip Morris.
Well, the company official also says, just a second, that you're represented by a union. You have a union representative, and that if there's anything wrong, your union takes care of it. Now, is that true? Are you represented by a union?
I have been with the company for 26 years, and I just had the opportunity of becoming an operator. And I've been questioning them, talking to the union, and talking with the officials as high as I could go up. And I still had, the first time I had this opportunity.
In deciding to take a case, we look for what are the implications of the case. What leverage will it have? Will it interpret an important federal statute? Will it make a new legal precedent? Sometimes a case won't make a new legal precedent, but it will make an important social precedent. A case requiring desegregation of a large industrial plant in a major city, even though it doesn't make any new law, will have a tremendous impact for that city if it actually brings about integration. So we look, will it be a social precedent, or will it be a legal precedent? That's the kind of thing we look for. We look for the case that will have a big multiplier.
This is the Creighton Court housing project, one of 5 all Negro housing projects here in the city. And the 5 plaintiffs in these 5 cases, all of whom are standing on the steps over there and standing out in the yard, are 5 ladies who have had children out of wedlock. We filed suits sponsored by the Legal Defense Fund, challenging the right of the authority to evict these tenants on the ground that they had had children out of wedlock. Our theory being that these policies were unconstitutional and violated these 14th Amendment rights of these tenants.
And they said that you are allowed one child, illegitimate child, after you move in the projects. Well, I haven't had but one in the projects, and I've been married and I'm divorced. And they said that my first child by my ex-husband was illegitimate. She's 9 years old now, but they still count that as illegitimate.
In other words, they don't make it a difference to the way I understand that rule.
Inside or out, I don't think they have anything to do with your affairs outside the projects. I think it's what inside the projects that counts.
Well, we don't think they have anything to do with your affairs inside the projects in this respect.
And it's nowhere in the lease that says anything about that.
Well, this is a rule that they have adopted.
They have made it up themselves because the little slip of paper that they do give you, to sign if you have one. I think I signed one in 57, and I had only one child then. And it's just some typewritten thing, nobody's signature or anything on the bottom. So that's not legal to me.
The vice in this particular rule, and the reason why we think it's unconstitutional, is that the law is seeking to punish children. And the purpose of the federal housing laws is to protect the children and low-income families, punish children for so-called immoral activity on the part of the parent.
As you know, we're representing several community organizations in Newark, New Jersey, who are opposing a project to place a medical college in the midst of a densely settled Negro area, as the college is now planned. The college has been planned to occupy 150 acres in this area and to displace, according to our estimates, over 10,000 people in a city which does not have adequate housing to replace the housing which is being taken and no plans to do so. The groups we represent further object to the fact that the health facilities to be provided by the college do not relate to the health needs of the community, but rather there is an intention to develop a teaching hospital which will take a small number of interesting teaching cases, a person with an interesting kidney problem, interesting liver problem, but not responsive to the health needs of that particular community. There's no objection to plans to place a medical teaching facility in the area if it was designed to occupy a reasonable amount of land, if there was a housing program that was prepared to rehouse the people to be displaced, and if the medical facilities to be provided related to the health needs of that community. Mike, didn't our city planner show in this case that the 160 acres would house the 20 largest medical schools in America? As the average medical college probably occupies no more than 10 to 15 acres. Well, the newest medical school, Mount Sinai, which is a first-rate school, occupies, I think, about a block and a half. This is a classic Negro removal case where the effort is to reduce the Negro population in the central ward of the city.
This whole project just stinks to high heaven of political maneuvering, because as you can see right here from our map, which is pretty much the bulk of the central ward, which is Newark's Black Belt, you have a medical school. It's going to take up 150 acres of land. You have a highway coming through here, which is going to take another large amount of acreage, not to mention the people that are going to be taken out. Now, just dwelling on the medical school per se, Newark is a city that has 60% black people or more. They say 52, but they don't count the missing black people. In 1970, there's a possibility that there may be a black mayor. So what they want to do, and what they will do if this thing goes through, is to displace thousands of voters from the rolls by 1970. Now, some of those people will just move out of town. Those that don't move out of town will go into other parts of the city. When it comes time to vote, if they are in fact registered, they will go to their old place of voting, or they will go to a new place of voting and find that they are not eligible to vote there.
This project is located in the midst of the riot area in Newark, and many of the participants in the organizations were directly affected and involved, as everyone in that area had to be in the riot. They're looking upon this effort really as their last attempt
to present their grievances in an orderly manner. They've called upon the assistance of lawyers, of city planners, of architects. They've presented their grievances in a way in which I know no community to have done so. We have filed a complaint. There have been numerous conferences with federal, state, local authorities. If this considerable effort to present grievances in this manner fails, the community, I think, will become considerably dispirited, and the very conditions which we're attempting to react to will merely be aggravated.
Mike, let me interrupt you for a moment. You went up to Ossining yesterday to see, I think it was yesterday, to see about the road that's going to be built up there that's going to wipe out a Negro community. What is the status of that at the moment?
That's an interesting comparison to make to the Nashville situation. The road in Ossining is a road, New York. This is Ossining, New York, is a portion of the Hudson River Expressway, which passes by white communities. And as it passes by white communities, care has been taken to see to it that no houses are taken, no businesses are affected. As a matter of fact, the state has been planning to fill in parts of the Hudson River to assure that there will be no damage to white interests. But as it reaches Ossining, which has a Negro community, the road was diverted inland again to pass through the Negro community, taking about a third of it in its path.
We've got into this program in largest part because we've started employing experts, city planners and people like that, who know how to go into a community and analyze it. And the lawyer goes in there, he really doesn't know what in the world's going on. And you can't calculate relocation rates and what is proper land use and so forth. You're pretty much at sea. But now that we've been using experts, we've had the capacity to do this. As I see it, the question is just what are we lawyers doing? What are we accomplishing? Well, you start in, you've got the statutes of the United States, and you've got the Constitution of the United States, and you've got the decisions of the courts, and they kind of reach on down from Washington to the states and the local government. But then there's this gap. How do you kind of take this and connect it up with the people? Now, traditionally, in our form of government, the way that's been done is either the public officials have obeyed the law on their own, or somebody's gone to court and compelled them to obey it. Well, the essence of our problem is that they have not obeyed the law on their own. The Constitution has required that there not be segregation, but people nevertheless segregate. The Civil Rights Act of 1964 says labor unions and businesses nations can't discriminate, but they do. Hospitals can't discriminate, they do. Well, how do you bridge this gap? The way it's been done, indeed the only way it can be done, is that some lawyer goes into court and hands a piece of paper in and starts the machinery rolling. He invokes the law and he brings out the facts, and if the courts do their duty, as traditionally they have, then an order comes out and says that you may not segregate in the jury, and you may not discriminate in the Philip Morris Company, and you can't discriminate in the hospital, and you can't keep Negroes out of the hamburger stand, and you can't segregate in the school, and so forth. All these things we've been talking about. Unless a lawyer does it, it doesn't get done.
We shall overcome. We shall overcome.